The judge, Ty brings up the tweets, I said tweets, texts, and the affidavits in regards to Kamehacon. And remember, the judge is reading them. And the judge asks, what damages did Vic suffer at Kamehacon? This is a criticism that people have of Ty. And people have different theories on what it was. I have one criticism of Ty on the TI argument, okay? And I'm going to put it out there very honestly, is Judge Chupp kept saying that how did he word this? I'm trying to think of this. I didn't write down his specific wording, but he basically said they fixed the breach of contract and remedied their original agreement. Okay? They remedied their agreement. And this is my criticism of Ty from my Monday morning quarterback perspective, is I would have firmly said, no, Your Honor, the first agreement was breached and void. The second agreement is a separate agreement. That's where I would have liked Ty to go. Again, why he chose not to is his answer, and that's a strategic play. That's what I wanted to say is, no, Your Honor, we do not concede that this was a fulfillment of the original agreement because there were material changes to the contract that one, are additional costs and loss for my client, and two, took even further loss to remove or to get to, because time and effort and money had to be expended to engage in discussions to renegotiate the contract, or as I would label it, negotiate a new contract. I wanted desperately for Ty to come in there and talk about that. He did not do that, and that, again, that's a choice on how these things go. I'm not in control of that. And Ty may have made the right decision. I don't know. That's what I wanted to see. And we don't know if that would affect the outcome in any way. But that was the argument I wanted to make. This is a separate contract. And the only reason, it doesn't ultimately matter in the legal analysis, but the only reason is to highlight those damages more precisely. To suggest, no, Your Honor, the damage is the first contract was gone. My client had to come in and renegotiate a new contract with new material terms that changed it. But either way, the judge asked, what damage did Vic face? Ty said he had to pay for security. That was not part of the original agreement. He had to relocate his table. That was not part of the original agreement. And he had to do something else. Wasn't part of the original agreement. These are material changes to the contract. Oh, he didn't get to do any panels. And the judge asked, did that cause him damage? It's like, well, yes, some damages. How much? We don't know. And that is actually an appropriate answer because you don't know what the damages are specifically at this point, and those damages are subject to argument from the other side. For a prima facie showing, all you need to know is that there were any damages. The court doesn't foreclose a cause of action just because it's less economical to pursue it. If someone wrongs you for $1, you can sue them for that dollar, even though it will cost you much more than that. That's part of law. That's part of law. So the fact that the judge said, well, those aren't enough damages, and then dismissed the TI is mind-blowing. It was mind-blowing. Because the judge asked Ty for something, Ty actually gave it to the judge. And it's right in front of him. It's in the affidavit he's reading from Chris Latosh. He gives it to the judge. And the judge says, not enough damages. But $1 is enough damages. One penny is technically enough damages. Damages, the actual amount is a fact question. It needs to be resolved by a finder of fact. So, why did the judge dismiss the TI? Because the judge absolutely improperly applied not only the prima facie evidence, or the prima facie standard, he misapplied a preponderance of the evidence standard as well. because there is no contra evidence. There's no one who says, no one in that courtroom said Vic incurred no damage, except for the judge who just decided that he didn't incur enough, I guess. Because he didn't even say that Vic incurred no damage. He just wanted more. But that's not the legal standard for TI at all. And so he tosses out TI with existing contracts, TI with business prospects. What do you do? What do you do? At this point, Ty is actually getting visibly frustrated with the judge and changes his tact. He changes it. Initially, he's a little more deferential. He's self-deprecating. He's making kind of jokes. There's a line going around where the judge asks, "Are you even listening to me?" And he's, "Well, no, Your Honor." He's making a self-deprecating joke there. I must not be listening enough. Ha ha ha. The judge wasn't having that. At this point in the hearing, Ty is pointing vigorously at the affidavit. We have them doing it, Your Honor. We have TI right here. It's right here in front of you. We have them doing it. Not only do we have prima facie showing, we can prove it. It's right in this affidavit. It's right here. The Kahn versus Vanderlinden case says that you couldn't produce an affidavit from the Kahn owner. Here it is. Well, then the judge wanted affidavits from other Kahn owners. But you don't have to produce affidavits from other Kahn owners at this point. You don't actually have to do that because the TI survives on Kamea Kahn alone. And the TI with business prospects survives on Kamea Kahn alone. Of course, in the record is Ron's text saying that Monica and her agent will be contacting other conventions to also tell them that, and that is prima facie evidence of interference with other conventions. I don't think that was brought up. That's another criticism I have of Ty. But at this point, when you say, "Judge, it's right here on the paper," and he says, "Dismissed." You can understand why some things might get missed, or at least I can. I can understand why some things might get missed at that point because, "Judge, it's right freaking there. It's right here. You're looking at it." He says, no. So that was lovely. Now this is getting kind of late in the hearing. The judge is now dealing with a more combative attorney, and there you go. Yeah. Oh, yeah. Judge dismisses both TIs against Real. I do have another note criticizing Ty at this point. I don't know if it's Ty or the judge, but they were saying attempted tortious interference with Kamea Kahn. And again, I don't want it to be attempted. It's not attempted. They did interfere. They did interfere with Kamea Kahn. They caused damage. They caused the breach. Interference occurred. It wasn't attempted. I know the judge kept saying it. Ty might have said it too. I don't remember specifically. And if he did, that's why I wrote it in all caps on my page. So that was a criticism I have of Ty. But you can make your determinations on if he definitely should have said that. But at this point, he's been arguing with this judge for 2 hours, and the judge is applying inappropriate standards. Why didn't Ty give the judge the evidence? When Ty tried to give the judge this, basically this, okay? Or when he tried to read the cause of action with the evidence off of the second amended petition, the judge said, "I don't want it. I have their binder." That is far from fair, highly prejudicial, and probably appealable. So Ty did try to present this evidence. And if he could give the judge the binder with the tabs to show the judge where the evidence is, so he could say, "Okay, judge, you want evidence of the TI for this person? Flip to this page. There you go." Judge said, "I don't want it. I have their binder." Again, that's not something you can prepare for because a judge isn't supposed to do it. So, anyway. And then Schwazoom says, "Speaking of TI, I know cases where defamation TI cases were won and the winners were only given $1 because no damages were proven. How can Chup throw out the TI entirely based on not being able to prove damages to his liking past hiring security in TCPA?" He can't. It's reversible error. He can't do it. But he did because he's a judge, and judges can do it. It just can be reversed.